Gurbanova versus City of Ithaca.
Good afternoon, Your Honors. My name is Tom Bowman of the law firm of Coughlin and Gerhardt. With me is my colleague, Craig Specht. We represent the plaintiff appellant, Nazifa Gurbanova, individually and as the parent and natural guardian of ZM, a minor in this case. This case involves a...
Did you wish to reserve time for rebuttal?
Thank you for the reminder, Your Honor. Yes, I wish to reserve 3 minutes. This case involves a heavy metal bollard or parking barrier that was negligently installed by the City of Ithaca on City of Ithaca property onto a patch of asphalt. This happened in 2016. In 2019, this barrier fell, and when it fell, it struck my client, injuring her.
So the question here is the prior written notice statute, correct?
Correct. And the city has asserted a prior written notice defense. The defense was successful at summary judgment at the trial level and at the appellate level.
Counsel, I'm curious about an argument that this is not the type of defective condition that would require notice. And it appears that's touched on in the Supreme Court decision, but did you make that argument at the trial court?
Yes, indeed, Your Honor. At issue throughout this has been, is a parking barrier a street?
No, I understand that. It's not a highway, but this is a slightly different issue. This is, assume it is a highway. Is this a defective condition such that it would require notice?
Your Honor, I argue no for multiple reasons.
No, but did you raise that argument?
Oh, yes.
Okay.
Yes.
Did the court address that argument? Did the Supreme Court address that argument?
Judge, it's been quite a while. I'm not sure that they did, but I have routinely argued that this type of defect is not the type which falls under the protections of a prior written notice statute.
And why wouldn't it?
Well, firstly, the precedents of Doremus and Anderson, which those courts are engaged in a strict construction of the statute, which is required as these are in derogation of the common law. And those cases both recognize that the type of defects that these statutes cover are defects within the surface of a street or a sidewalk.
Well, we've said that appurtenances, so things sticking out of the pavement, right, apply. But here, I mean, the bollard is just a bigger appurtenance, so why should there be a different rule?
So, Judge, that's a good question. And,
Thank you.
you know, I have my point one, which is that I believe the Court of Appeals needs to return to this issue and restore a little bit of order as to how these statutes are interpreted and applied. And I believe a return to Doremus and defects within the surface is appropriate, but I'll move on from that and address the subsequent law. So Hughes added a layer of analysis to this issue by stating, firstly, where a municipality installs an object, they have actual notice of it and don't require prior written notice. So that's one reason why if Hughes is applied, the prior written notice should not apply here.
Wait, you're saying that from the minute it was installed, it was defective? Is that the argument?
That's the argument that we've made, and that's the argument that my expert opinion has put out there.
This was installed in what year?
2006.
Okay,
And
and
then-
this accident happened,
2019.
okay.
And then
Isn't there a requirement that you have to show that from the initial installation it was defective?
There is, if the prior written notice statute applies, but we argue that it does not. So the other aspect that Hughes adds to the analysis is that the defect, Hughes states, and I'm paraphrasing, needs to be of the type that does not immediately come to the attention of city officials unless they have prior written notice. Now, again, the city installed these barriers, and 2 or 3 years after installation annually, the city forester, Mr. Hillman.
So does it have to be immediately dangerous or immediately apparent that it's dangerous, or both?
I don't think it's either if we're looking at Hughes. I don't think Hughes is...
If the written notice statute applies,
Okay.
what's the rule?
If the written notice statute applies, then there are a couple exceptions to the requirement. One is the affirmative creation of a hazard, which is immediately dangerous.
But that's the one that we're saying, assume for a second that it was not defective upon installation. What else is there to avoid prior written notice?
Well, if we're assuming that it's not defective from the moment of installation, then...
Because this is the sort of defect that's not immediately apparent to a municipality in the absence of notice, right?
I don't agree, Judge, I'm sorry.
You could see that that was defective and dangerous without notice of that?
Judge, you know, much as in Hughes, where the defect was a utility pole, you know, a series of engineering decisions were made to place that pole where it was and to install it how it was.
But
and the
you
same
don't
thing is
have,
true
you don't have a negligent design claim here. You're saying that this was a defective condition.
Judge, we've been saying all along that this was negligently installed, and that's what our expert opinion says, and it was dangerous from the moment of installation.
What about the evidence that it had been inspected periodically up to some number of years before the accident happened, and it wasn't showing any sign of defect?
Well, you know, what do we really truly know about the nature of those inspections? And by the way, this is self-serving testimony from somebody who was employed by the city at the time. I mean, tugging on these barriers, how much force was used, you know? We don't really know what that actually
Yeah, but at
tells
some
us.
What-
point, they had to take a chain attached to a truck to remove some of them.
Well, some of them, yes, not the one in question, for sure.
But doesn't that undercut the argument that it was defective upon installation? There seemed to be this consensus among some of the judges below that this has to be the kind of thing that develops over time. It gets loose over time. And I take it in order for your cause and create theory to survive, you have to reject that theory, right? Because basically you're saying this thing was a hazard from the day it was put in.
Our judge, our expert, has opined that
But what supports that besides the expert asserting it? What evidence shows that immediately when it was put in, it was dangerous?
so our expert's opinion is based on his lengthy experience in the engineering field. His asserted opinion is that asphalt is simply not a dense enough material to support a bollard that was installed in the way
But
that
that's
it was.
equally consistent with the theory that over time, it will loosen and could do exactly what it did when your client was swinging on it. But I don't think it fully answers the question of whether that was the probable result from the very day it was installed.
Judge, I have to go on what my expert has opined.
Yeah, but it was just a statement. I mean, he didn't point to any data or any scientific evidence that the asphalt couldn't withstand this cement bollard. He just made a statement, and why should that be sufficient?
Sure. The statement is based on his experience through years in the profession.
So
And this is
by the
sorry.
way, what was that in terms of the expert? What was his statement with respect to his experience that would give him the necessary expertise to opine on that?
Judge, that's in the record. I believe the whole affirmation is in the record. I'm not sure exactly where it is in the record, but his experience is laid out in there, and it's decades of experience with.
I took a look at the affidavit. He says he has experience in the construction industry, but there really isn't a lot of detail that would give me confidence that, I don't mean to be coarse, but that he knows what he's talking about.
So, Judge, the appellate division recognized that he's eminently qualified to make this decision, and the city of Ithaca
Sorry, the
didn't.
appellate division recognized.
That he's qualified to make this opinion. It's right there in their decision, and that was not challenged by the city of Ithaca. So that I would argue that's honestly not really before the court. The lower courts decided that this was a qualified expert.
Yeah, but again, the opinion is that you wouldn't use this is not a proper foundation because the bolts aren't going to stay, which again means over time, this is going to get loose and potentially hurt someone, and anyone who wants to install this would think twice about installing it in that kind of a foundation. That strikes me as what the thrust of the expert opinion is.
Yes, and I think we should look at what the expert affirmation actually is and says. And again, this is a reason to return to whether this is or is not a defect that falls within the statute. I think one thing that the dissent got very right was to bring in Groninger.
How much time went past before this happened?
Between installation and the accident, 13 years.
So that there was a passage of time, which is arguably consistent with this is a condition that developed over time, as opposed to immediately dangerous.
And again, I return to what my expert has says, and this is the only competent expert opinion in the record.
But it seems to me that the entirety of that statement is at paragraph 8 of the affidavit, and he says, "Bollards such as these should never be installed directly into an asphalt surface. Asphalt, either porous or traditional, is not dense enough to keep the bolts in place and not designed for that purpose." And he goes on and says it should be in concrete instead. So that alone is sufficient in your view, that those couple of sentences.
Absolutely, Judge.
And why isn't the appellate division correct instead to say that there are key pieces that are missing from that? For example, some showing more than that bare assertion that there was an immediately apparent dangerous condition and that it was not secure upon its installation.
So, Your Honor, opposing counsel and the lower courts have sought to impose requirements on my expert.
I'm reading from
that-
the appellate division's
So
opinion, though.
the appellate division focuses on, well, why weren't there codes or, regulations or
Well, the appellate
studies
division just
referenced?
says, I think, that fatally missing was any showing that the alleged negligent installation led to an immediately apparent dangerous condition.
Well, I think the clear import of the expert's affirmation is that with the proper force, these bollards are going to fall over, and it's not necessarily reliant
Were
on the
these
passage
supposed to
of
be
time for that to
permanent?
happen.
Were these supposed to be permanent?
No, Judge, that's the other thing. They weren't supposed to be permanent. They were supposed to be in place until the trees that they were supposed to protect grew to a sufficient height, and the city just never
So maybe
got rid
it's
of
not
them.
dangerous if the foundation would have held for that period of time?
Judge, I don't know. I only know what my expert
Well,
affirmation
that's what I'm
says.
saying. The expert didn't necessarily opine on that.
No. I can tell that the court is very interested in the quality of my expert's affirmation, but I would love to address whether or not this is a defect that falls within the statute. Now, we've looked at, the dissent looks at what is the function of a road, and the road is to allow vehicular traffic, right? And we've always said a road, this bollard is not a road, and we've always said it was put in place to stop traffic. That is contrary to the purpose of a road, which is why I believe the dissent says, not only was this placed outside of the parking lot, that's arguable, but that it was placed outside of the purpose of the parking lot and outside of the purpose of a road.
Well, you could have things inside a parking lot that are to route traffic certain ways, right?
Correct.
Dividers, that sort of thing. Would those be part of the road?
Well, no, I don't believe those would be, because their purpose is to stop traffic and redirect it. And the legal definition as defined in Groninger is, and the purpose as defined in Groninger is access, for vehicular traffic.
Thank you.
Thank you.
If it please the court, I'm David Twitchell. I'm here on behalf of the city of Ithaca.
I have a
would like
question
to
for you.
address-
Counsel, I have a question for you over
Sure.
here. With respect to the bollard, did it have to be both immediately dangerous and apparent, or is it just that it had to be immediately dangerous?
The immediate danger is the standard.
So you would agree that the appellate division adding the apparent portion was not necessarily accurate?
Well, that's a very interesting question, Your Honor, because very recently, in the Calabrese case, this court used those terms.
But weren't those terms used based on the nature of the work that was performed? There was a problem with the road, and you could see it, and it's just stating what the facts were.
Right. If this defect in the alleged defect in this bollard was immediately apparent, then counsel would have an argument that it was immediately dangerous.
So what if the bollard had been, right in front of you, what if the bollard had been installed into sand? Would that be immediately apparent, an immediately apparent defect?
It's hard for me to say, but sand is not going to support a ballard, I wouldn't think.
Yeah,
You'd have
and
a
what if no child swung on it for 10 years? Would you have needed notice somewhere or not?
Well, that would have been discovered, though, when Mr. Hillman went out and tugged on it with his hands and arms.
Is it clear that he tested all of the bollards?
Yes, that's.
Each and every last one?
All of them, yes.
Putting his full weight on them?
He
Is
says-
it clear from the
He says
record?
he pulled on it with his hands and arms.
I appreciate the fact that you're trying to answer questions based on real facts instead of my hypothetical, but I would like to try you again on the hypothetical. Let's suppose nobody tested it, right? It's installed in sand, right?
Okay.
From the beginning, but no child swings on it for 10 years, and the first time a child swings on it, it goes boom, and the child is hurt, as here. Is that a defect that you would say was apparent, the installation of the bollard into sand from the beginning, that would not then require prior notice, or not?
Well, I suppose it'd be a function of how deeply it was installed. Was it firmly installed? That's what Mr. Hillman went out to.
Well, suppose there's an internal memo from the town saying, we know we shouldn't install bollards in sand, but it's too expensive to put concrete in, so we're going to put it in the sand.
Well, I think that situation would have been discovered when someone went out and.
Yeah, that's not, again, my hypothetical.
Counsel, don't you think it's possible that there would be a judge out there who would say, I don't even need an expert affidavit. If you install a bollard in sand, that is a dangerous condition. It's within the ken of the layperson that isn't something you should do. Don't you
agree.
think that's possible?
I agree. That's not something that you should do, and I think a
Which is why it's good that the city didn't do it here.
layperson would know that.
Can I ask you a question about, could we go back to, well, we might be talking about prior written notice, but I want to go back to something that I think Judge Garcia started all the questioning with, which is this defect, even assuming that it was okay when it was installed and it became loose over time, it's not the sort of defect that one normally associates with prior written notice in the sense that it's not appreciable to anyone who's not taking the time to test it. In other words, you don't really know that this thing's going to fall over until a 5-year-old girl comes and swings on it and it falls over. So I'm wondering, I guess my question is, how would you even get prior written notice of this? And if it's impossible to get prior written notice, or practically impossible to get prior written notice, maybe the prior written notice law shouldn't apply in this situation?
The municipality has a prior written notice law. If there is no immediate dangerous condition supported by some facts that show that.
I don't know if it's immediate, but it's dangerous. I know that on the day of the accident, it was loose enough that the weight of a 5-year-old girl could knock it over. So I have a strong suspicion that something dangerous was there on the day of the accident, but it's not appreciable. That's my problem. And I don't understand how the municipality would have gotten prior written notice of it, because it's not appreciable.
Maybe I don't understand what
Let's
you
say
mean
it
by
was a
appreciate-
bridge, highway, it's a bridge. There's this similar type of defect that Judge Canataro described, that when the bridge is installed, it's fine, but over time, something is happening. Car goes over the bridge, car falls into the Hudson River because of this defect. would you say that, let's say it's a town owns that bridge, they would have required prior written notice of the defect underneath the bridge?
I would think that in that situation that you described, that if the municipality had a prior written notice
Right.
provision, that
And what
prior
would
written
they
notice
get,
would be required.
what would somebody give them notice of? Like, I was flying my drone under the bridge, and it's like, I don't see how that's a defect subject to somebody seeing it and saying, you know, you get notice of this. So it seems like there's something of a gap to me between, you know, obvious pothole, something you can see and you get notice of, and a condition that is immediately dangerous that the municipality creates, which gets you an exception out of there, and this other type of defect, which develops over time but isn't noticeable.
What purpose does the requirement serve in that circumstance? In other words, whether it's under the bridge or whether it's a bollard that you won't know is loose unless you pull on it, the condition is not going to be apparent to the eye. So I'm not sure what would give rise to prior notice, because I'm not sure anybody would notice it. So what purpose is the requirement serving there, other than to protect the city from liability?
That is certainly one of the factors.
It is, but I thought that one of the reasons for the requirement was to put the city on notice so that it can repair, and if it doesn't repair, then it may face liability. And in a circumstance where nobody's going to see the defect because it's not appreciable to, to the eye, and I'm not sure how it's serving that function of giving the city the choice to repair or face liability.
Let me suggest an answer to you, and let's see if you adopt it, because I'm not sure I buy it myself. But if you come from the place that we're talking about a law that's in derogation, essentially, of sovereign immunity, and it has to be strictly construed, that there are going to be some classes of defects for which notice is practically impossible to give, but that's just the way it goes, because we're coming from a place of a baseline approach of immunity. The municipality is immune from suit.
Of course, that has to be a function of what the actual defect is.
Let me try it another way. Let's say that what this rule would boil down to is, it's almost like the dog bite rule that we had. There has to be an injury. Some kind of injury occurs, or the defect, or the piece of material falls off, or whatever it is, and that would have otherwise given the municipality notice to have acted. And as society, we're willing to accept perhaps some of that danger.
It's like a
To be
one
fair.
bollard rule.
Yeah. The one injury rule. Although someone need not be injured. It could be the bollard had fallen, someone sees it fall, but no one ever reports it and no one's ever looking at it.
Right. I understand, I think, the question, but the whole purpose, as I understand it, of a prior written notice law is that a municipality cannot be expected to know what's going on with all of these things like highways and streets. Cities have
True,
miles.
that's why it was, the reason I said this was, one would have to then say that society is willing to accept the potential harm because the municipality cannot otherwise actually appreciate this. And nevertheless, we want bridges built, we want roads built, we want ballards put up to help these trees grow, to protect the trees,
I have a question for you. With respect to the, what needs to be in an expert affidavit, Can an expert simply rely on their experience without citing a code or a regulation that was violated? Or
My
statute?
understanding, and I have cited a number of cases in our brief, is that an expert opinion must have an evidentiary foundation. In other words, there must be some facts.
So I'm going back to the hypothetical. I've been building things, and I know that you don't put bollards on sand. I know this because I know they're not going to withstand the pressure, and that it's immediately dangerous to do so. It's contrary to all standards, even if they're not written, practical. I know by experience this is not the proper place to put it. I can't rely upon that.
The statement in this case, which is similar, you shouldn't install bollards into asphalt because they're not dense enough. You need more than that. That's an opinion, that's not a fact.
So it can't be an opinion based on my experience in this type of work.
So if he had said, so the density of the asphalt is X, the density of concrete is Y, in my opinion, you can't install that bollard in the asphalt because it's density X, you need to install it in the concrete because it's density Y, and that would ensure that it wouldn't topple over.
That would be a more appropriate way for an expert to express an opinion that he or she would expect a court.
But that's still just based on their opinion, right? There's nothing to suggest that perhaps X is fine as a minimum.
You don't need a code, right? You don't have to have a code that says bollards shall or shall not be installed this way. That's not a sine qua non for an adequate expert affidavit, is it?
No, but if you're going to say bollards should not be installed in asphalt because it's not dense enough,
Yes.
that's an opinion that needs some facts. The facts being, what is the density?
Yeah, but even if you said that without something that explains that, I guess some objective view is that that density is insufficient, we're back where we started.
Well, not really if we credit the expert with experience with bollards, with the knowledge of.
Well, that's what I'm saying. Why does it matter that they give the actual number, in my hypothetical, of the density if they're saying, this is my experience, I know this area really, really well, here's my years of experience, they're recognized as an expert, and I say what appears to me in some way so self-evident. Once an expert says, it's not dense enough, you're understanding their point. The foundation cannot withstand the pressure with this bolt.
But it's not dense enough is an opinion, and it seems to me.
But all I'm saying is that would be an opinion even if, in my hypothetical, which I thought you were agreeing, that might have been enough. If they say asphalt is, I don't know, I'll make up a number 2, concrete is 4. We still don't have anything that gives us the baseline of why 2 is not enough and 4 would be enough, other than that expert's very opinion.
And the expert may have to go farther than that and say why 2 is insufficient and why 4 is sufficient.
So can that ever be based on, even if he didn't say this? Let's say he said, I have installed bollards for 5 years, and I would never put in asphalt because it's not dense enough. Is that good enough?
He's installed bollards
My
for
hypothetical.
years, and
Yes.
when
Yes.
he installs them in a material that has a density of 2, they're not stable. That would be the kind of fact that would.
He has, from his experience, he has to have said he did it the wrong way, and that's how he knows?
Well,
That's not the expert I want.
study them the right way, but then, as a practical matter, businesses would be interested in why do I have to buy more expensive concrete? Can I do it with less dense concrete?
But a sufficiently qualified expert, someone who has the requisite degrees, and as Judge Rivera was saying, I've installed bollards, I worked for DOT for 20 years, I've been involved in roadway construction in multiple areas, and I can tell you, based on my expert experience, that you do not install bollards in asphalt. Now, I'm not saying that's the expert we have here, but that expert has to be sufficient without even talking about relative densities and things like that. Is that not so?
Well, I know that from my experience that you do not install bollards into asphalt because they
So
don't.
there has to be an explanation of the physical forces at
There
play?
has to be an evidentiary foundation, factual support for what the expert says. I think you'll find that in the Diaz and other cases.
So a
that I-
conclusory opinion that this just isn't done wouldn't be sufficient.
That would be my view of what the law says, yes.
Thank you.
Your Honors, I'm conscious of having gone over my time already. I'd just like to make a quick point, and this goes again to Hughes, which is, opposing counsel has said, well, the city's not expected to go out and know every little thing that happens in all of their streets, but that is not true of the object here. This is a heavy, brightly yellow painted object that was installed by the city and inspected several years after it was installed. This is clearly an admission that this is an object that requires the attention of the city. This is not an object that escapes notice. And with that, unless Your Honors have other questions, I'll leave it.
Thank you.